and I'll be tendering those letters in. So I cannot go against what the letters say and the contract say, because I was the agent at that time. Jakpa business was the agent.
Hold on. LC's on site. Payment shall be in yours. First, if we said there shall be no advance payment.
Yes.
What does advance payment mean?
What it means is that you are not the supplier was not going to be paid any cash, any money for him to use in procuring all the accessories and everything to manufacture. So the manufacturer will use his own money to buy the ambulance vans, all the accessories from across the globe, with the security from government being the LC. And the LC has conditions precedent.
Hold on. Okay. Yes, advance payment now means paying in advance of the delivery of the goods.
They said no advance payment.
Yes, advance payment means that you are paying before the goods are delivered to you.
No, they said no advance payment. Not that there's advance payment. Yes. No advance. Meaning that you will not pay.
Yes, until the goods are delivered to you. No, sir.
Yes.
So until the goods are delivered, you don't pay at all.
You don't pay.
Also, so, and then also it goes out to say that payments shall be in a free manner. LCs on site of goods. In fact, what is the even LC on site of goods? What does it mean?
What LC on site of goods means is that when you ship the documents, when you ship the goods, when you ship the goods from your port of origin, the bill of lading of the goods is what you use as
on site of goods means when the goods have been shipped.
They have been shipped.
And then the goods have been delivered in Ghana.
No, when the goods have been shipped, because you have gone to do pre-shipment. So what I'm trying to explain is that so you use the bill of lading. You use a bill of lading.
You pay only after the goods have been delivered, because that's also the contract, not so.
Yes, but then the financial instrument for the project is an irrevocable letter of credit. So that credit letter has already been sent.
Hold on, no problem. But in my view, that letter of credit area, the contract requires that you pay by letters of credit, not so.
Yes, in addition, we should establish it upon the front of the contract. So already you have paid.
Upon the signing of the contract for every 50 ambulance.
Yes. Upon the signing of the contract for every 50 ambulance, since there was no advance mobilization, advance payment, that LC was a security that you have to establish ahead.
No problem. It's on the contract for every 50 ambulance. Is it the contract for every 50 ambulance?
Pardon?
Is it the contract for? I'm saying upon the signing of the contract for every 50 ambulance.
Yes.
Is it the contract for every 50 ambulance?
The contract is for 200 ambulances in tranches of 50.
Good. Hold on. So that contract for 50 ambulance is different from this one?
No. It is, the contract is one contract for 200 ambulances, which has been broken down within the contract for every few. You establish LC for every 50 tranche. So you have 4 LCs for the 200 ambulances.
No, that part I disagree with you. But if you look at the terms of the contract, it's quite clear. And it should not be difficult for you to accept, because really it doesn't put you in any problem at all. That does not put you into any difficulty. And you know the Minister of Health, the Minister of Finance. So for me, if you accept that, then it doesn't put you in any difficulty.
The problem I have in accepting that for you, is that in there are letters that confirm that, both from government and from our principal, that is for every 50 ambulances. That confirms that. And I'll be tendering those letters in. So I cannot go against what the letters say and the contract say, because I was the agent at that time. Jakpa business was the agent.
Hold on. LCs on site. Payment shall be in yours. First, if we said there shall be no advance payment.
Yes.
What does advance payment mean?
What it means is that you are not the supplier was not going to be paid any cash, any money for him to use in procuring all the accessories and everything to manufacture. So the manufacturer will use his own money to buy the ambulance vans, all the accessories from across the globe, with the security from government being the LC. And the LC has conditions precedent.
Hold on. Okay. Yes, advance payment don't mean paying in advance of the delivery of the goods.
They said no advance payment.
Yes, advance payment means that you are paying before the goods are delivered to you.
No, they said no advance payment. Not that there's advance payment. Yes. No advance. Mean that you will not pay.
Yes, until the goods are delivered to you. Also.
Yes.
Yes, so until the goods are delivered, you don't pay at all.
You don't pay.
Also. So, and then also it goes ahead to say that payments shall be in a free manner. LCs on site of goods. In fact, what is the even LC on site of goods? What does it mean?
What LC on site of goods means is that when you ship the documents, when you ship the goods, when you ship the goods from your port of origin, the bill of lading of the goods is what you use as
LC on site of goods means when the goods have been shipped.
They have been shipped.
Not and then the goods have been delivered in Ghana.
No, when the goods have been shipped. Because you have gone to do pre-shipment. So what I'm trying to explain is that so you use the bill of lading. You use a bill of lading. You use a bill of lading.
You establish the LCs after pre-shipment inspection. No dispute about that.
No, the LC is established as soon as you sign the contract. You establish the LC, and that becomes the security comfort for the supplier to invest his money.
It says LCs on site of goods are returned upon the signing of the contract.
Yes.
For every 50 ambulances.
Yes.
Yes. Which contract is this? It's not a contract for every 50 ambulances. So under this main contract, this was like the main contract.
The main contract and LC for every 50 of the 200. So the contract is not saying that government should establish one LC which is 15.8 million euros for the whole 200 at a go. No. Government has a bulk contract of 15.8 million euros. Now, this contract will become, the ambulance will be coming in tranches of 50 ambulances. So you establish your LC for the 50. When that 50 have been delivered and everything sorted out and handed over, another LC is established for another subsequent 50 until you finish all the 200. That is what the contract says. So the LC that was established.
Even then, no. I don't agree with your explanation. But even then, this explanation, that's not what happened in this case.
Okay, what happened?
Yeah, that's not what happened. Yes, because the LC was established even before pre-shipment inspection.
Yes.
Also,
yes.
There was no pre-shipment inspection. So it means there was no basis for the LC to be established in the first place.
No.
That's really not your problem anyway.
Right, that place, in that particular place, you are getting it wrong. If you may have patience for me to explain to you. No. You are getting it wrong there because when you establish LC, the LC had conditions precedent for it to be honored. And the condition precedent states that you can only cash the LC when you present shipping documents, which is bill of lading, to the Ghana International Bank of the buyer before the LC can be honored. So even though the LC was established upon the signing of the contract, was supposed to be established upon the signing of the contract, it cannot be cashed or honored. It becomes a form of security for the supplier to invest his own money. And when he ships the ambulances, he can then send a bill of lading to your bankers to then honor the LC, because that is a condition precedent.
But in any case, in this case, even the LC was actually cash. Everything. That payment was actually made before the goods were shipped.
No.
The goods got to Ghana.
No. Oh, yeah. He couldn't have the supplier. There is no way under the sun he could have cashed the LC before the shipping document, which were condition precedent, was presented to Ghana International Bank. Even when he presented the documents to Ghana International Bank refused to honor the LC, raising issues of discrepancy, which came back to Bank of Ghana, which later went to the Ministry of Health, and then Animana authorized Bank of Ghana through Ministry of Finance to pay because they had sorted out the discrepancies with Big C. That time, around this time, or the ambulances had already arrived in Ghana. You are not privy to this one, I'm telling you.
In my view, if we agree to this theory, it's so simple. The theory of the case.
Not agree to the way you want to go. The way you want to go about it.
So let's agree. Let's describe it that way. Let's describe it that way. Do you want to go about it?
Okay,
if you agree to it this way, it makes it simple.
Yes, it will make it.
It doesn't also involve. It doesn't involve any difficulty for you.
Yes, I agree. I understand your point.
When you say there's no advancement, yes. When you say there's no advancement, ordinarily meaning in Ghana that you don't pay until you get your goods. Now the contract here, even the clear terms, unless maybe you guys did not draft the contract, it says everything on site of goods shall be established upon the signing of the contract for every future.
No, it was the contract was drafted by government. It was done by government.
Oh, yes.
And it was an LG department perused the contract and approved the contract for government.
It is not a problem where they approve it. Every contract is actually approved before later when they implement it, then problems.
You see, what the difficulty I have with your position is that, you see, frankly speaking, fine, as you are saying, if I agree to your position, how you want to go about it and how you want me to go about my answering questions and things, if I go by that way, frankly speaking, I'll be dishonest because I know that is not how it's supposed to be, and I'll be dishonest in such a way that I'll be assisting for someone I know is completely innocent about this. For example, Atu Forsen to be jailed because I knew something was wrong, was not the way, and I decided to keep quiet and to answer the question in a way that will make your case better for you to jail him. I'll be battling with my conscience. That is the problem I'm having. Anytime you bring up this issue with Yoni Kulendi, when I went to Yoni Kulendi's place, anytime you bring this issue, that is my problem I'm having. Because me, for example, I am in this case because I'm innocent and I'm going through ordeal. So I'm looking at another person also going to go through ordeal and through me because I know the truth and I decide not to say it because I want to help the AG make his case. And I ask myself, what is my interest in it?
I'm not asking you to really help me. I'm just going by it. But anyway, so that's fine. So this one was even just by the way.
I hope you get my difficulty.
It's on the phone. I don't even know that.
Oh no. No, don't worry about that one. My issue I'm talking about. Oh no, you and I will be meeting. You'll be meeting me at my cousin's place, and you've been bringing this issue up several times. And I keep telling you that I can't do that because it doesn't sit well with me.
Look at the terms of contract. The terms of contract are simple. It is on site shall be established upon the sign of the contract for every future with us.
Yeah.
The answer. Yeah.
It's for every. So when you see that hand for every 50 ambulance, means that it's not only the 50.
Okay. Yeah. Okay.
For every. It means that it is not only 50.
All right.
Mean that there are a lot of 50s that will be following. So that is what I was trying to explain to you. So frankly speaking, the LC that was established was as a security for the supplier to invest his own money since there's no advance.
Yes, it is the same purpose used to pay. Because LC was the means of payment and the agreement.
Yes. When the conditions precedents are met.
Is what they have some documents.
And the bill.
Contrary to what the third accused knows and believes to be the truth. We have in our possession a series of recordings in which the Attorney General, Godfrey Dame, is clearly heard goading, urging, impressing upon, and actually coaching Mr. Jakpa to bear false testimony against the minority leader, Dr. Atufosson.
The National Democratic Congress also calls for the resignation of the Attorney General, stating that it has not practiced within its principles.
The immediate and unconditional resignation or dismissal of Godfrey Dame for bringing the high office of the Attorney General and Minister of Justice into disrepute and public opprobrium. Clearly, Mr. Dame is not fit to hold himself out as Attorney General and Minister of Justice. He is unfit to be the leader of the Ghana Bar. 2, the immediate prosecution of Godfrey Dame for multiple violations of the laws of Ghana. We wish to make it clear that should President Akufo-Addo refuse or fail to prosecute him, a future NDC government will prosecute Godfrey Dame for this heinous crime of fabrication of evidence. 3, commencement of disciplinary proceedings by the General Legal Counsel against Godfrey Dame and his disbarment for conduct unbecoming of a lawyer, and more importantly, the leader of the Ghana Bar. 4, a publicly televised parliamentary inquiry into this and other reports of judicial manipulations by Godfrey Dame with a view to censor Godfrey Dame to prevent the recurrence of such judicial manipulations.
Vanessa Edutum-Boateng, reporting from the National Democratic Congress headquarters, Accra.
In all these endeavors, the NDC filed a motion for censure to remove Godfrey Dame from office as Attorney General soon after his appointment, but this also failed. The NDC have since his appointment held over 12 press conferences against the person of the Attorney General. What at all do the NDC want from this young man? The youngest Attorney General the country has ever produced is working in the best interest of the nation. Yet, these people will not let him rest. The latest allegation by Dame-Jakpa, the third accused and an associate of Kesela Atufosson in this Bosch procurement is therefore only a further ploy contrived to curtail the prosecution of Atufosson and smear the Attorney General's integrity and reputation. But this, I can assure you, will not work. We firmly believe that public officials, regardless of social standing, must be treated equally before the law, and they should be accountable for their use of public resources. Needless to say that the law is no respecter of persons. Ladies and gentlemen, the allegations by Dame-Jakpa that the AG has on several occasions met him in private at odd hours and in person on phone to coax him to implicate the accused person is a complete variance with the prevailing facts. In fact, it is laughable. The attempt to selectively present facts without the whole is telling of the intentions of the third accused person. For the record, it is unacceptable that Johnson Asiedun Ketia will run a commentary over the alleged tape calculated to prevent Ghanaians and discerning people as such from making their own deductions and reasoned judgment. You saw him on radio behaving like a choir master. Again, even though from the screenshots displayed, the alleged conversation is supposed to last 26 minutes, the NDC schemed to play only 60 minutes. 16 out of 26. The question is, where is the rest of the tape? Even in respect of what was played, it is apparent that there are repetitions, overlaps, incoherence, voiceover, and distortions, demonstrating that the NDC has spent these past days distorting whatever tape they played. It is no wonder that even this afternoon, we are caught in the same trap anyway. Even this afternoon, instead of commencing the press conference at 2, they had to wait till about 3 o'clock because they were still doctoring. We haven't doctored. We are presenting to you the facts as they are. Even on that doctored tape, the Attorney General never requested the witness to falsify, fabricate, or concoct any evidence or testify in the prosecution's favor. You all heard the tape. Where did the Attorney General lure the third accused person to prefer evidence against the first accused? With the load of evidence before the court, how can the Attorney General manipulate the third accused person? Indeed, if the prosecution had not made any case against Atuforse, the judge will not call upon them to open their defense. Let us throw those accusations in the dustbin of worthless material. Again, on the question of who initiated the meeting, even from the NDC's presentation, it is clear that if any meeting at all was called, it was mooted and initiated at the instance of the third accused person. We would like to put it on record that as of February 2022, when Jakpa requested for a meeting with the AG never met him and never made any arrangement to the Supreme Court Justice, Emmanuel Yoni-Kolendi. It was not until the AG was invited to the residence of His Lordship Justice Emmanuel Yoni-Kolendi in 2023 that he surprisingly met with Jakpa at his residence. We remain resolute and very firm in our minds that the Attorney General has never approached the accused person for any conversation, let alone request him to skew his testimony against first accused Gisela Atuforse.
The issue that has arisen now relates to alleged conduct by the Attorney General,
right,
as the one who is actively prosecuted in the case. And I think the starting point is the allegation by the witness in the witness box that the Attorney General somehow tried to compromise him.
Right.
I mean, in connection with the trial.
Right.
Now, because of the hue and cry that has arisen, it's important to point out that we have a law in this country relating to matters that are in court which the parties may wish to settle.
Right.
There's nothing absolutely wrong with either party to a criminal matter or even a civil matter wanting to settle out of court.
Right.
But there are rules regarding settlement out of court. In the criminal trial, we've got the plea bargaining law.
Right. The
essential character, or what in relation to what's going on, the first point that we like to observe is that if parties want to settle a matter and the parties are represented by lawyers, then the matter is properly settled or properly confronted or properly talked about between the lawyers. Now, in the particular context of this case, the Attorney General is the lawyer for the state.
Right.
And therefore, if he wishes to initiate any discussion with a view to a settlement or anyways, not only settlement, some of the negotiations could involve getting some of the parties on one side to turn over to your side. There's nothing wrong with that.
There's nothing wrong with that?
Absolutely nothing. If you go back to the U.S. as I'm speaking right now, one of the several suits against Trump, the Attorney General has successfully succeeded in getting about 4 of the accused persons to come on the Attorney General's side on various agreements by which they've agreed to give evidence against Trump, even though they all started the suit charged with the same or similar offenses and whatever. So it is a practice. I mean, it is of the essence of a trial that the parties should be able to settle out of court. And for that purpose, the law tries to aid them within confined guidelines, if I may put that way.
Okay.
That is why we have this plea bargaining law in this country. And the plea bargaining law, the essential character of the plea bargaining law is that if the person is represented by a lawyer, then the negotiations must take place with a lawyer. This man was not represented by a lawyer.
Right.
If he was not represented by a lawyer, nothing stopped the Attorney General for engaging him one-on-one. As to the purpose for which the Attorney General engaged him,
Well, it gets more and more interesting and more intriguing. I'm talking about the Yato Forson's ambulance trial case. Good morning, and thank you very much for tuning in to Inside Pages. My name is Aldo Moro. It's always a pleasure coming your way. It's a Saturday morning as usual, and this is where Ghana listens to, and this is where Ghana watches every Saturday morning from 8 to 10. This is Inside Pages. Now, as you may be aware, and if you've been monitoring the media airwaves, it's been a back and forth between the NDC and the MPP, and also a back and forth between lawyers for the third accused. I'm talking about Dame-Jakpa in that ambulance trial case, and the Attorney General on the one hand. And there have been a lot of legal twists and turns as far as this matter is concerned. And so the lawyers have been very busy this week, and they're going to be busy this morning as well here on Inside Pages. But the latest is that there have been two applications that have been filed. So yesterday, there was an application that was filed by Dame-Jakpa, the businessman. He's filed through his lawyers, at law. He's filed an application in court, seeking the court to, among other reliefs, strike out the charges against him, or alternatively, to stay the proceedings. Now, in his witness statement, Mr. Jakpa, he testified under oath and said that Attorney General Godfrey Dame has had several interactions with him, etc., etc. He is requesting that the court allows him to testify to these matters and to be cross-examined on same. So that's one part. But the Attorney General has actually applied for, so the Attorney General has actually replied to, or has reacted to that application. And of course, he's objecting to that application through the latest that he's just filed. And we'll give you some of the reasons why the Attorney General doesn't think that it's a good idea. In fact, he calls what Dame-Jakpa and his lawyers are engaged in as theatrics. That's how he describes it. So that's one topic for this morning. The second topic for this morning is that, well, just in case we're following the impending Ssnit asset sales or share 60% to Rock City Hotel Limited, which is 100% owned by the Greek minister. The latest in that episode, if I may call it, is that Labour has been. I'm talking organized Labour. They have been meeting the Ssnit board, and this was based on an intervention or a directive by the president. The president says, "Look, Labour, go and sit with the employment minister, and also sit with the Ssnit board and iron out whatever differences that you have." So organized Labour have been doing that, and organized Labour says they've made some progress. So Ssnit has now told them that the deal has not been consummated, it's not been closed at all, and that they're still contemplating and they're still considering some bids and some proposals. That's quite interesting, because the initial impression we had was that it's case closed, Magana Yamutu. But now Ssnit is telling us that, well, they're still considering bids. So it isn't as if the deal is done with Rock City Hotels Ghana Limited. So that's what Ssnit has been telling organized Labour. Organized Labour's position on this matter is still the same, which is that we will not agree. We will not allow you to sell 60% of the shares of these hotels to the Greek Minister's Hotel, which is Rock City Ghana Limited. So we're hoping that we'll have some time to deal with those issues, with that particular issue. But we'll start with the Attorney General's matter. I'll take a short break. When I come back, my guests would have been seated and the conversation will start. Stay tuned in. All right, welcome back. This is Inside Pages on Metro Television. As I did indicate, we have two topics to look at. We're looking at the back and forth between the NDC and the MPP as far as the ambulance trial case is concerned. The leaked audio, which has now become the center of which is at the center of the controversy. The NDC says that they have incontrovertible evidence that the Attorney General has been involved in all kinds of things. The MPP said it's not true, and that what the NDC has played is actually a doctored tape, and so nobody should take the NDC seriously. The third accused in the matter, Dame-Jakpa, who is a businessman, has actually filed an application in court. Now he's asking the court, or he's praying the court to strike out the charges that has been brought against him, or alternatively stay the proceedings. And he's also asking the court to grant him the opportunity to testify to some matters that he has brought before it. And he said he has some volumes of documents and evidences that he wants to tender, and he wants to speak to those, to those documents. So that's one. But then the Attorney General himself has actually responded to Richard Jakpa. Now, the Attorney General, just last night, late last night, he filed another motion where the Attorney General's office has described Richard Jakpa's motion to strike out the charge against him as an extension of the public theatrics deployed by the third accused to discredit the prosecution against him. Now, he says that he's debunking all the allegations that have been raised against him. The Attorney General is also arguing that the prosecution, however, is based on cogent evidence unearthed after painstaking investigations conducted. And it says for the Attorney General, the depositions in the affidavit in support of the instant applications are laden with spurious allegations which are carefully and mischievously calculated at creating unnecessary anxiety about the capacity of the court to dispense justice in this case. Now, the Attorney General also states that the instant application is an extension of the public theatrics that the accused person has resorted to in a bid to discredit the prosecution of this case and cast doubts about the integrity of the proceedings in this honorable court. All of which the Attorney General has so far observed utmost professionalism about, in spite of the persistent insults and abuse to his integrity by persons associated with the accused persons. And so this is where we are as far as this matter is concerned. And I also mentioned to you that we'll have a second topic when time permits us. We'll talk about the latest with intended offloading or the disposal of 60% of Ssnit shares to Rock City Ghana Limited, which is 100% owned by the Greek Minister, Mr. Dame-Jakpa, who is also the Member of Parliament for, I've forgotten the name of, what's Dame-Jakpa's constituency again? It escaped me. He's also an MP for one of the constituencies, the Eastern region. It's escaped me, and when I remember, I'll tell you. No, not in Price. In Price is actually, what's the name? In Price is this other guy. Yeah, but it's not in Price. When I remember, I'll let you know. But that's where we are. But also the other thing that has also been revealed by the Member of Parliament for North Tong, that's Samuel Okujeto Ablakwa. He says he has gone through the financials of the 4 hotels that Ssnit intends to offload 60% to Rock City Ghana Limited, and these hotels are in sound financial position. And in fact, as we speak, Labadi Beach Hotel has 65 million Ghana cedis lying in the account by way of profit. That's what Samuel Okujeto Ablakwa was. And in fact, he said he has the documents to back that. And so nobody should deceive anybody into thinking that the hotels aren't doing well, and that's why they have to be sold to or divested to Rock City Ghana Limited. And he also raises issues about the track record. So Rock City Hotel has been in operation for barely 5 years. What is the track record? What's the capacity to run these 4 hotels? In fact, he thinks that it should be the other way. Labadi Beach should rather be swallowing Rock City Hotel. So that's where we are. So we're hoping that we'll have time to talk about that. But let's start with the interesting twists and turns with this ambulance matter. Now, we do know that this week, the NDC held a news conference, the MPP held a news conference. The NDC said the AG is, in fact, they are asking the AG to resign because, according to them, he has misconducted himself by engaging a witness or an accused person in a trial before the courts without the presence of his lawyer, and he breaches the professional conduct or his professional code of ethics. So those are the issues they are raising. And the MPP held a counter press conference that same day, and the MPP said, no, what the NDC is saying is not true, and that they are involved in what he calls as a comedy. And so nobody should take the NDC seriously. And the AG is focused on doing his job, and so on and so forth. And they're even questioning the authenticity of the tape that the NDC played. And then we also see what has happened to the latest applications that have been filed. So to put all of this in perspective, I have joined my resource persons who are here. Ambassador Sampiale is at some point Ghana's ambassador to India. He's worked with Ssnit for many years. He's retired, obviously. And he's now the president of the NDC's Professionals Forum. And he's joined us this morning. In fact, this is the first time he's joining us on Inside Pages, so we're grateful. Thank you very much. Good morning, sir.
Thank you so much.
Thank you so very much. He's also a private legal practitioner. That's one of the things. He's a lawyer, very seasoned lawyer, as such. So he knows exactly what. So he knows his law, he knows about Ssnit, he knows about insurance, etc., etc. Let me also say that I have Ernest Adade. Ernest Adade is one of the, you can call him the latest kid on the block, one of the eloquent communicators of the MPP, very brilliant chap. I've heard him several times on some other platforms, and we are happy to have him join us this morning on Inside Pages. Ernest Adede, good morning. Thank you very much for joining us.
Thank you too.
Thank you so very much. We'll also be joined by Zoom. Professor Osai Kwapong is the project coordinator of the Democracy Project. He'll also be joining us via Zoom shortly. And also, lawyer Justice Abdullahi will also be joining us to help put some of these legal issues in perspective. I mean, he's not a politician, and so I'm sure that even though Asampiali is a politician, he's a lawyer, you'd say he's a politician, but that man, he's not. So depends on which of the analysis you want to take. So this is where we are. So I'll start with Ernest Adade. Now, I mean, what do you make of these applications and the counter applications that we're beginning to see? You have Dame-Jakpa saying that I have evidence. I need the court to give me an opportunity for me to come and tender these pieces of evidence. They call it depositions. And I want the court to also give me an opportunity to speak to these evidence. But at the same time, I want the court to discontinue the case, strike it out, or stay proceedings, because I do not trust that this Attorney General would discharge his job fairly and justly. What is the Attorney General seeking to do with all of this? I mean, you are very close to, you speak for government. Yeah. You're close to the Attorney General. Help us understand why the Attorney General thinks that it's not a good idea.
Okay, thank you very much. Thank you, and my greetings to the ambassador. We've met before. Unfortunately, I don't want to remember. I don't want to believe he remembers me.
Yes.
Ambassador, you are welcome.
Right.
Greetings to our viewers also. And yeah, those Attorney General issue.
So he's a member of Parliament for Abetifi. Yes. Thank you. Yes.
My worry has been, why are we discussing this here in the public domain?
Okay.
When the issue is in a court of competent jurisdiction,
right.
One. All the matters and the issues that are going on are currently happening in court. The Dame-Jakpa accusation commenced in court,
right.
Before the tape and the press conference of the NDC came up. Anytime you speak to people within the NDC, they will tell you that when I asked somebody, why don't you present all these evidence in court, so that we will all save ourselves the trouble of attempting to understand
right.
What is going on. We have a situation where there's a conversation that ensued between two people.
Right.
Is now on trial. The two of them spoke. What led to their conversation? That conversation, we don't know. We don't have the background. The tape as we have it, I keep saying that if I have listened to the tape over and over again,
Before you go ahead to talk about you listening to the tape over and over again, let me just share or advertise the WhatsApp line for people who want to join us. It's 0249-155-646, 0249-155-646. That's the WhatsApp line. Please join us with your thoughts on what you make of what's going on with all these applications and counter applications. What's your understanding of what's happening? And where do you think all of this is leading us? 0249-155-646. You can see that on your screens. Please go ahead, sir.
Yes, so two people had a conversation. We heard a part of the tape. Some of them are saying he didn't intend to record, and for that matter, he couldn't start early. He decided to record it midway. A lot of us do not believe that. You remember the letter you just read.
Yeah.
The Attorney General's department came out with that letter, that communique, telling the whole world what the issues are. They did not believe the Attorney General. From the beginning, they did not believe the Attorney General had any conversations whatsoever with the accused persons, especially the third accused. Also, they raised a number of issues in that letter. We all went to market with it. We started talking about it. I am an MPP person speaking for the party. So we all started raising issues that if this is the case, then why are we having this conversation? We saw letters from Richard Jakpa's lawyers. We saw there were communications that were released into the public domain. So we all know.
Right.
In the Attorney General's letter, something was mentioned which I think is worthy of noting.
Okay.
They made it clear that there was no meeting, number one. And the state, the word they used there was that the state, or he said the Republic has never required or desired the cooperation of any of the accused persons in the matter.
Okay.
So this is from the Attorney General's department.
Right.
It's on the letterhead of the state. Then, when you go down to the bottom, it said the Office of the Attorney General and the Ministry of Justice considers the latest allegations leveled against the Attorney General as part of a grand scheme by the NDC to put more pressure on him to discontinue the prosecution or to divert attention from the real issues on the ground. So many issues have been mentioned here. The Attorney General is prosecuting people, and issues are happening outside in the public domain. And I always ask, all the things they told us, we have heard from Richard Jakpa. We have heard the conversation between the two of them. Right. Up until now, I haven't heard the Attorney General say that conversation never ensued. So I am assuming that some form of conversation ensued. Right. But the MPP came out to say that this is not the whole story. The whole story. The last time, the NDC confirmed that this is not the whole story. And the guy started recording from somewhere in the middle of the conversation. You could hear Richard Jakpa trying to lead the Attorney General. He says something and then he puts it to him. We don't have the background. Right. I have said it on several fora that let the Attorney General, we've heard from Jakpa, we've heard Jakpa's tape. I want to hear also from the Attorney General. At least the lawyers tell us that you give an ear to both sides. You will have to hear the other side too. And we haven't heard directly from the Attorney General yet. People are saying his spokesperson had spoken, and this is from his department and all that, and for that matter. But the release and the tape is giving us two conflicting issues. We never met. The tape is saying otherwise. We, the party, are saying we don't know anything as such because the state on the Attorney General's letterhead is saying that meeting never took place. And we've been given a tape, and like the NDC was mentioning, they have videos and things. Now it's been proven that there is a tape, at least if it is not the whole tape or it's not the accurate tape, there is a tape. Because we all heard the Attorney General's voice. Knowing the Attorney General's voice, I will not sit here and say that may not be the voice. Right. I know also that technology exists for anybody to want to play tricks with whatever I am saying now. You can cut, you can put it, you can edit what I'm saying now, and it will look like me. Everything said. You can go and take a voice of mine. Maybe I have said something somewhere on another tape. You can take it and fix it into what I'm saying now for it to look like it is the same thing. It's possible. The only way for us to be able to authenticate that will be through a forensic investigation on this tape, right? That case is in court. Jakpa and his team have presented this. They are asking the court that they want to present this in court. Yes. Is that not it?
Absolutely.
If they take it to court will not just take it, swallow it, hook, line, and sinker, and walk off. The court will by all means order an investigation on the tape. So that, Jakpa is saying you said it, the MPP as a party had come out, not the Attorney General, to say that we suspect or we smell something fishy on this tape. Okay. We're smelling some rats somewhere on this tape. Right. The NDC, remember, the people who had that press conference are not parties to the case. I repeat, I want to underline this.
Technically speaking, the NDC is
they are not parties to the case,
Yes,
whether technically or not.
Yeah, but politically they are. Because the minority leader is there on the ticket of the NDC.
So if politically they are,
yes,
they are doing the political bit.
Right.
That is not the legal bit, right? So I have said,
but it is the same context why Frank Davis, who is the chair of the legal committee, decided to organize that press statement.
Because it is the NDC that spoke.
Exactly.
Not because it is, if it were the parties within the case.
My point is that if, by parity of reasoning, the MPP could have decided not to respond to the NDC, even though the NDC had spoken, to say that, well, it is the Attorney General, and the Attorney General's office have more than enough communicators, apart from Isaac Wilberforce Mensah, who speaks for the office. There's also the deputy attorney. In fact, you have 2 deputies, okay? And I'm sure there are other people who can speak. In fact, there are some of your communicators who are lawyers who, from time to time, the media will speak to on matters of law, legal matters that comes up in this government. My point is that once the MPP as a political party has deemed it necessary to respond, it is because they see...
To respond to who?
To respond to the NDC.
To the NDC. That is the question. That is the issue. Okay, if the NDC did not jump into this matter with this allegation, the MPP would have had no case. The case remains in court. And as we speak, the case is still in court.
Okay.
So, if when the lawyers were exchanging letters with the AG's department, did you hear any press conference from the MPP?
Right.
So, once the NDC gave itself that power to now become the quote and unquote the advocates for the accused persons because they are their members, the MPP will jump in and speak to the issue because the Attorney General is also a member of the MPP. So let's separate the political party matter. Yes. This is what I want to drive.
And I'm also saying to you that the way you have put the issues, which is that the NDC is not a part as far as this suit is concerned. It is between the states, the AG, of course, the AG prosecutes on behalf of the state, Richard Jakpa and Ato Forson. Okay. And your point is that why has the NDC taken it upon itself to be speaking for Ato Forson and to some extent Richard Jakpa?
To take the case out of the judicial processes.
Good. And I'm saying that
into the public domain.
So I'm saying that couldn't the Attorney General's office, for instance, could have said what you said when the NDC held
the Attorney General's office responding to the NDC.
To say that we will not respond to the NDC because the NDC, as far as we're concerned, the NDC is not in court. The matter is being dealt in court.
No, what I'm saying is the response to the Attorney General's, the response from the Attorney General's department, is that you are impugning or you are maligning or whatever word you want to use the Attorney General, who is part of that office. In fact, he ends up being the head of that office. So the office acted. Now, the NDC organizes a press conference. They didn't go to court to say we want to join the case because we have something to do with it.
Right.
They organized a press conference. Automatically, the thing had been taken out of the realms of the court into the political arena. Specifically, there are two political parties that back what is the conversation.
Let's do this. I'll come back to you for you to continue because we have Justice Abdullah on the phone. So we'd like to talk to him and come back to you. But chew on this. Just ponder over this. The conversation that took place between the Attorney General and Jakpa and the Supreme Court Justice or Judge was not in court. It was outside of the court.
The AG's letter told you that. Yes. We never authorized any such conversation. That's the letter you just read.
No, but
you can reference it.
Yeah, no.
The state so there are did not send anybody to have a conversation.
There's two communications from the office. One is official. Okay, so one is on paper and one is not. Let me put it that way. So the one on paper said there was no meeting. Exactly. There was no communication. There was no engagement whatsoever.
Exactly.
Then you had the spokesperson of the Attorney General coming out to say that, well, there was actually a meeting. But the meeting happened in the house of a Supreme Court judge. That's not the same as what was issued on the 23rd of April.
There is a tape also telling us otherwise. The tape
that is a phone conversation.
The tape we are discussing
it's
now
about the phone conversation.
It's not the conversation that the spokesperson said happened in the in somebody's house,
You have
right?
a point. You have a point. I'll come back to you. You have a point. I'll come back to you. So let me do this. Justice Abdullahi, good morning. Thank you very much for joining us. Hello, Justice Abdullahi. Hello, Justice Abdullahi. Good morning. Yes.
Good morning, Moro.
Good morning. Thank you very much for joining us on the Inside Pages.
It's always a pleasure, Moro.
Yes. How is soccer this morning?
I left earlier, so that's why I couldn't join on.
I know you don't joke with your morning exercises
No.
and so on. So yeah.
It's part of building Mother Ghana.
All right. Help us with a couple of issues because we are laymen, we are mere mortals, and so we need some education from you. Now, you have an application filed by the third accused. Yeah, I'm talking about Dame-Jakpa, who's a businessman, who is asking the court to strike out the case which has been brought before it. And I'm talking about the ambulance trial matter. And he raises issues with there's some pieces of evidence he has based on some interactions he has had with the Attorney General, and actually believes that based on those interactions, he does not trust or believe that there will be fair trial. And so he wants the court to strike it out. He also wants the court to give him an opportunity to come and speak to the evidences that he has been able to collate or gather. Because remember, there have been a lot of talk about this evidence has been doctored and so on. The man doesn't have anything. He's engaged in theatrics and so on. The man says, okay, you give me an opportunity to come to court and bring these pieces of evidence with me and come and speak to it. And I'm actually ready to be cross-examined. I'm told you lawyers call it a mini trial. What is this? Tell us more about it. Of course, you also know that the Attorney General has responded and said it's not necessary. The Chief Justice should ignore him. What is a mini trial? And in what instances, what kind of situation can justify a mini trial? And what is it meant to achieve?
All right. Thank you, Moro. So just by way of clarification, it's not the Chief Justice that the AG is asking to ignore. It's a trial court judge that has jurisdiction over the application that is being urged to ignore this application.
Okay, thank you.
For me,
much.
that comes as a complete surprise anyway, because all of us are seeking to bring the truth out of this issue, just so the dignity and the reputation of the Attorney General's office would be preserved. So solely on that basis, I was of the opinion, strongly for that matter, that the Attorney General would support this call for the what you want to call mini trial to be conducted.
That's true, because I had Alfred Etia Yeboah who said he's all out for it because they have nothing to hide. So you're absolutely spot on that.
Exactly the point. Yeah. That's what I expected, because I mean, really, at the end of the day, you want to put out the truth, because what we are hearing in public clearly does not advance the dignity and the reputation of the office of the Attorney General by virtue of these controversies. And so it would have been a wise decision to support it. Having said that, usually when you talk about mini trials, usually it is targeted at on resolving a particular issue within the whole suit, no matter. But there are specific instances where courts would ordinarily engage in a mini trial, and that is normally when maybe there is a piece of evidence that for a reason or two is contested, and the court might either summarily determine to admit that, or will conduct a trial, which is sometimes called mini trial, over that particular issue. Typically, this happens when, for instance, there is a alleged evidence of confession evidence or other matters that the state would like to impute the accused person to have said. and then it becomes a matter of contest because the accused person probably would deny, naturally would deny, that he didn't confess to the commission of the crime. But the state has evidence of it, that indeed, in the presence of an independent witness, this person confessed committing this sin of crime, and so it ought to be admitted. Now, under such circumstances, the court then would ordinarily conduct a trial to verify and take other admissible evidence to verify in order to take a decision as to whether this evidence ought to be admitted or not. There are a few other instances where, for instance, the whole suit, and normally this happens in a civil matter, where the whole suit is sought to be struck out for reasons that would be outlined by the applicant, by an applicant. And in such circumstances, too, many trials could be conducted, or in some instances, the court will simply just ignore it and then say that rather than conducting a mini trial to determine whether or not to strike out the suit, I would instead want to pursue the whole suit, and if the matters you have there to come up, then I would as well just throw out the case at the end of the trial rather than conducting a mini trial. Okay. So there are a few instances where these things happen, and normally it's on the admissibility of evidence. And so, having said that, I don't know whether I would allowed to proceed or just...
Yeah, please proceed, because it looks like you have an opinion on the matter. And then because I have some substantive questions that I want to ask you, but I would allow you to tell me your opinion on the matter before I come in with my questions.
Right. So having briefly discussed what the mini trial is, as I was saying earlier, my opinion of the application was that the alleged evidence, I'm not a lawyer on, of course, doing the case, but I would have thought that in filing the application, the lawyer would have added those pieces of evidence to the application.
Is that what you guys call depositions?
Not necessarily depositions, because these are exhibits. These are video recordings. These are audio recordings, and that are alleged to be out there in the public. And so I would have thought that it would have been added. But what I noticed was that it appears that lawyers made, or at least, even if you not add the video or the audio, a transcript of it probably would have been added as an exhibit. But what you notice is that they did not do that. The applicant did not do that. What they did, rather, was to make references to the conversations and the meetings rather than adding these exhibits. Naturally, I know the lawyers are very smart, and so I fear that the reason for taking this approach was to avoid the possibility of the Attorney General applying for those exhibits to be struck out because they are not admissible in court. And so any lawyer finding himself as Jakpa's lawyer would have these technical difficulties to grapple with, which is why I believe in the application are insisting on the what's it called, cross-examination of their witness. Because normally, if you bring an application, you cannot say that you would want to be cross-examining just so you can put your case better across. That is not a typical scenario. You bring your application, so you have to bring all your evidence and everything else. And when the other side also comes, of course, the court has the power to allow for evidence to be taken when the application is to be heard, depending on the particular circumstances. That power exists that the court can invoke to say that, okay, you know what, you are moving your application, but because A, B, C, D are not clear, I would like you to mount the witness box so you can be cross-examined and be heard on the matter. And so if any lawyer who knows what is happening will tell you the difficulties that they are going through. At one point, you have the evidence, but because of the nature of the evidence, you are unable to tender it. Yet you don't want the truth to come out. And you can't tender it because you know that it is inadmissible in law. it is likely to be rejected because it was recorded without any of the parties' consent. So, because each party allegedly secretly recorded this meeting and conversations that took place. And once you do secret recordings, the authorities are that unless there's a special circumstance there, it's likely to be thrown out. So this is why I believe the first lawyer had to adopt this approach to get to that same position through another means, without necessarily having to bring themselves forward, and for the application to be thrown out also on the basis of obtaining an inadmissible evidence. And so this is the difficulty we are all faced with. Now, if they did that and the court had thrown out the application, then it would have been so easy for anybody to accuse the state of having maybe high-handed, trying to hide the truth from coming out or prevent the truth from coming out in one way or the other. And so then the best approach would be what they are adopting. Cross-examine me. If after the cross-examination, you think that if you give me the opportunity to be cross-examined, then we can determine whether or not I am being honest, I'm being truthful, and I am being or whether or not I'm being mischievous. This is what Jakpa and his lawyer legal team are doing. And so if you can see it from within this context, then you can appreciate why things have been done the way it has.
So, Justice Abdullahi, two quick questions. How material will the evidences that Richard Jakpa claims he has to the substantive case which is before the court? You know, all these conversations and so who was there, who wasn't there, when, and so on and so forth. Do you think that it would be relevant or material to the case in court? That's one. Two, I've heard other legal brains or lawyers, let me put it that way, who say that the engagement that happened between Richard Jakpa and the Attorney General was ex parte communication. Now, ex parte communication is something that you lawyers say is without prejudice. So I trust that whatever I say or we discuss between the two of us remains absolutely confidential, because we are having conversations about plea bargaining or plea negotiations. And so you have no business putting out whatever or disclosing whatever it is that you and I are talking about. And so the court, at the risk of sounding prejudicial, but I'm told the court will struggle to admit it or to treat it as an admissible evidence in court, much less have any significant effect on the case before it. So two questions in one. I don't know whether you can help me with this. So ex parte communications without prejudice, you have no business putting it out, and once you put it out, in itself is a problem. And then number two, how substantive is that communication? That if indeed all the things that Godfrey Dame said to have said, the justice was there in that meeting and so on, can that be material to the matter before the court?
Okay, thank you. So let me attempt, within my humble, inexperienced legal brain. If it is, if you argue the way you have, then you are literally saying that the conversation that took place was official, first of all. It was indeed official. Second, you are also saying that indeed it was targeted at some form of plea bargaining. But unfortunately, all of these arguments fall flat on their faces, considering that even the AG is denying these meetings, first of all. So how then would one be right in arguing that there was indeed a plea bargaining? Second, plea bargaining does not in any way, would not in any way, call for some form of witness tampering. This is what we actually hear on the tape, at least from Jakpa's side of the event. he was being coerced to, as it were, do the first accused in. That is not witness tampering. I mean, that is not plea bargaining. Plea bargaining does not, you cannot compel a witness to make to give evidence that does not exist. That is not plea bargaining. That is coercion of a witness, and that is witness tampering, and that is criminal, and that is material in the substantive case. Assuming, as you rightly pointed out, all the instances are true, that cannot be on any form of borderline with plea bargaining. And of course, if the argument was that it was plea bargaining, then I would completely accept all that you're saying, that in such instances, then the conversation become such that the court would not be clothed with the authority to even know the details or anything that pertain. And so in such instances, then the court cannot even, we can't even talk about admissibility, because the court cannot even be aware of all that happened beyond the result, which is that maybe, assuming they even wanted to report to the court, because normally in plea bargaining, you are not even required to even report anything back to the court. And so there wouldn't have been all these arguments that are ongoing at the moment. So it is the nature of what we are hearing cannot be even on the borderline of plea bargaining for you to make all the arguments that you urged on me a while ago.
Okay. Why didn't Tadiosori complain to, say, how do you call it? Why isn't Tadiosori complaining that his client has had discussions or even petitioned the General Legal Counsel to penalize or to sanction the Attorney General for engaging his client without him being present? Because I'm told that per your Legal Professions Act, there's actually some act like that, or something like that, which guides the conduct of you lawyers. And per even the Plea Bargaining Act, as amended, you're supposed to be engaging in plea bargaining conversations with an accused person or a defendant in the presence of their lawyer. Now, assuming that there have been some conversations, because remember there are two meetings. One is digital, which is through conversations on phone, and then there's a physical one. We haven't seen that yet, because that's the one we're told happened in the presence of that Supreme Court judge. My point is that if these conversations indeed happened, and there's evidence to that effect, or there's evidence of same, why isn't Tadiosori complaining? Why are you and I complaining that why are you having conversations without a lawyer and that the AG has done something wrong? Shouldn't it rather be the lawyer of Richard Jakpa who should be complaining?
Well, that is reasonable and accords with common sense. However,
Okay.
you cannot question a lawyer's strategy to his own case simply because you think you know better. A lawyer decides to do his case with his own strategy the way he wants it. Possibly that is the reason. Maybe he has his eyes on a bigger goal, and we can see this through the application that he has mounted today at the trial court, asking the court to discharge his witness. Naturally, a lawyer wouldn't make that kind of application if he didn't have any particular goal in mind. Because this is one of the most difficult applications to be made because of the possibility of it not being granted. And so if a lawyer is going that tangent, clearly, I mean, without being a soothsayer, or my colleague calls it a clairvoyant, I would have to admit that he has a better strategy, which is why he's adopting this particular method, means of addressing his own case.
Is it perfectly normal? That's my final question to you before you go, because you may want to go play soccer again. I don't know whether you've been substituted or you're still on the field.
Attending to state matters are more important sometimes.
Okay, all right, that's fine. but Justice Abdullahi. So I was talking to Kweku Pencil on Monday on Good Afternoon Ghana. He's a private legal practitioner. One of the things he said was that let's even assume that Godfrey Dame was trying to get Richard Jakpa to do him a favor by incriminating Ato Forson, or to get Richard Jakpa to compromise on his stance and incriminate Ato Forson in that trial. Because Richard Jakpa is not the target. Ato Forson is the target. Now, Lawyer Kweku Pencil is arguing that there's absolutely nothing wrong. It's like if I arrested, a bunch of, say, 3 or 4 bandits have gone to create some problem somewhere. Armed robbers. You arrested one. You are able to use the one you have arrested to catch or to arrest the other 3. But then you have to make him a promise that, look, if you can help me arrest the other 3, I'll set you free. And so, per his argument, there is absolutely nothing wrong in getting a witness to compromise on the truth, for as long as it helps him to get the target, the ultimate target, and that's Ato Forson. And that he thinks is perfectly standard in your practice as lawyers or as a prosecution. What do you make of this?
So I respect my senior on the other side, except to disagree that I do not know whether he used those same words to compromise. Yes, it is normal to use one suspect or one accused person who may be within the scheme of things nothing to get a bigger fish. It is indeed normal to use someone else to get a bigger fish, because when you have the boss to deal with, you don't worry your head over what the messenger and those people do or say. So that one is normal. But it is not normal to say that, to compel those people against their wishes, particularly in this instance when they have lawyers and all of that, to give false testimony. Because this, once again, all these discussion is in direct relation to the conversations that are out there. But if you go on talking general about things, then you might lose focus on the real meat that has been discussed, and then you end up completely miseducating yourself. Generally, yes, you can use one witness to get other persons who are material, but do you do that by compromising on the set of evidence that they have or the kind of things they witness? Clearly not.
Shouldn't
false testament?
Yeah, but shouldn't the end justify the means?
No, the end doesn't justify the means when you use false statement. That would naturally be thrown out eventually if it is found out, because that would amount to miscarriage of justice.
I see.
You can't lie and get your way through. Then what then becomes? What then is the point of getting evidence?
So
what's the point of getting the truth out? What's the point in? Then you should also just bundle everybody in court and then get people to come and give false testimonies, and just with the hope that you get a political opponent or people that we do not desire to be in the public space into custody. That is not how things are done. Things are done in accordance with the rule of law, in accordance with best practices, in accordance with what sometimes we call moral constitutionalism.
I see.
You need to be able to affirm that the person has committed a particular crime. And you need to be able to get the evidence thereof adduced properly. Otherwise, remember we are all talking about this tape not being admissible and all, and I mean the possibility of the difficulties in admitting it in evidence and all of that. Have you asked yourself, if the conversations are true, why then are we talking about the possibility of not getting it admitted in court? And this is because due process ought to be followed at the end of the day. If the end justified the means, we wouldn't be talking about this. Then automatically it ought to be admitted, with or without the consent of each of the parties to the tape. So, just based on these circumstances alone, I think you should be able to form an opinion on that.
Okay.
That is a very difficult
All right.
position to adopt.
Just briefly, before you take leave of us, Justice Abdullahi, when you listen to the arguments that have been canvassed so far by critics of Godfrey Dame, do you think that they have sufficient grounds to ask him to leave, to resign?
So I think I am very clear and certain in my mind that the right thing to do is to resign because of the sanctity, the dignity, the aura of the office he occupies. It needs to be preserved. Not because I think he has done anything wrong at this moment or right, but because you do not bring that office into disrepute. This is my whole point.
Okay.
You don't, an office of that nature, you don't engage yourself such that it brings that office to public ridicule. It's not right.
Okay. Thank you, Justice Abdullahi, for your time.
Thank you, Morado.
Justice Abdullahi is a private legal practitioner. Let me come back in house, and I don't want to add this. You want to wrap up, or I should go to some Plea? You want to land?
I was raising an issue.
Yes. I made
when
you
said
land.
I should hold on.
I made you crash land. I'm sorry.
You made me hang in the air. You didn't allow me to land at all.
Yes, please go ahead.
So the issue I was making was that once the NDC took the case out of court and then put it in the public domain, they compelled the MPP to also come into the matter. Otherwise, it would have been a case in court versus a case between the AG's department, which is the state agency. So you see in their letter, they kept saying the state. It had nothing to do with the political parties behind. Now, these conversations, where we actually hanged was that these conversations were supposed to have happened. 3 conversations are now in the public domain. 3 conversations in the sense that, one, this tape that we heard, which is audio, and it's purported or it looks like it was on the phone. There's a second conversation that you referenced, that some meeting happened in a judge's house.
3 times.
And those meetings that happened in the judge's house, then this is we have videos. You have heard it.
Yes.
They say we have videos. The picture in this sense automatically to me is that, one, the gentleman Jakpa would have betrayed his brother big time. Number 2, this action is a strategy by the NDC or whatever to find a way to get their people who have been accused acquitted. It's a strategy, and anybody could use it. And the last time I was saying that Ghana at 50, for example, Kojom Pienim and Co. were in court. But the only way they were saved was because the thing went through, a commission of inquiry, and there are legal provisions that if the thing goes through legal commission of inquiry, you cannot take it and go and put it and use it against them in a court of law. So the case crashed. Look, if the NDC premeditated this action and they carried it out, it's the third problem I have with this issue. My own brother came to me that I have a case in court. My brother, your friend, is the AG. Therefore, go to the AG and get me. We do it in Ghana every day. If I have an issue, if I need employment, when Honorable was a deputy minister and I know him, I will go to his house at dawn and say, Honorable, there is an employment and you are a deputy employment minister, and for that matter, help me. We are Ghanaians. That's what we do. So he ran to his brother that I have a case in court. You are a judge and you know the Attorney General, help me. And you recorded audios, you recorded videos in his household. The man is so exposed. Because if these things, when they threaten that we have audio, they have brought it. So it's now giving me the impression that when they say we have videos of the meetings that happened in the judge's house, I no longer doubt them. So all I'm saying is that the case is in court. Let's allow the lawyers are doing their work as lawyers. They are writing letters, they are exchanging letters and all that. Let's allow them to do the work that way. And then when they finish, we, the commentators behind, can give the commentaries. But taking the case out of court and bringing it to the market, to the Mokola market for discussion, because the moment you hold a press conference, it now becomes gossip in town. Let me put it that way, quote and unquote. Gossip in town, everybody is discussing it. 90% of the people discussing it in the public may not necessarily even understand these legal jargons and these legal processes that are being mentioned. In the press conference, all the things happening, they don't understand. So it becomes, yes, they say, this one says, that one says. And it's not helping anybody. Let the case remain in court.
Right.
I am saying that, my first position was what the party took. Nothing happened. What the AG's department took, nothing happened. Then the tape came. And I can say, oh, I'm hearing some voice like Godfrey Dame's voice. And there are things happening like it is him. But I keep saying that the lawyers always tell, if you want to err, then err on the side of caution. Let's also listen to what Godfrey Dame has to say, not what his surrogate or somebody has to say. What has he got to say? What actually transpired? What is not on this tape that occasioned the voice that we are hearing? What is there that we don't know? And let's not only rely on the fact that Jakpa recorded something and what Jakpa is telling the public and what Jakpa brought should be sacrosanct and we should run with it and begin to crucify everybody. Look behind you. Viewers are seeing behind you. Look, you see the ambulances? We didn't see it in the previous situation. But I will be worried if an innocent man, if they didn't do anything wrong and they are prosecuted and jailed when they have actually not done anything wrong, I will be worried because it can happen to me. But if actually something happened, and we have to go through the processes to come to the end of it, allow the process to go on and don't take the case into the public domain and let us make noise over it. 2 weeks, the matter is dead and we are gone. And, we have lost money.
I think the point you're making is quite clear. Let's take the thing out of the court of public opinion and let's finish it in the court because that's where it belongs and not the court of public opinion. I think that's the point you're making. Anyway, let me come back to you. Let me come to now Ambassador Sampi Ali. What do you make of all of this?
Good morning, Moro.
Good morning, sir.
Good morning, my son. Now I remember why I know you. Like, this is my first time here.
Sure.
And as I do always, I issue a personal disclaimer.
Right.
That whatever I say here is attributable to my conscience and that it absorbs the station. That is not to say I'm going to make reckless statements.
I know, you're very, you're not that type of person.
I am fortified by the Constitution of my liberty to speak free speech. I also accepted to come this morning because if we don't take care, you will let politics destroy this country. I have heard various concepts, legal concepts, being given political meaning and interpretations.
Really?
A lot of them. Now, what has become very popular jargon now is plea bargaining,
yes,
ex-party communication,
yes,
and many others.
yes.
But the legal meaning of plea bargain is not you are going to plead, no. It is when an accused person standing trial, either is approached or he approaches the judge or the prosecutor to say that, look, I've been accused and charged with stealing. I am prepared to cooperate with the prosecution for a lesser offense and charge. Are you following me?
By so doing, you're admitting guilt.
The accused must first admit guilt.
To qualify to plea bargain.
To plea bargain.
Okay.
That is the law of plea bargaining.
Okay.
It's different from ADR. It's different from negotiations and it's different from settlement.
Right.
In law, every concept has its own ingredients. So for there to be plea bargaining, the accused person must first admit his guilt. And then by cooperating with this, you know what he's doing? Mm-hmm. He's saving the state money from a long prosecution. The courts are already choked. So if an accused person is going to stand trial for 7 years and he says, "Oh, my lord, I'm guilty, but I am pleading," then the judge would accept such a plea. That is called plea bargaining. You threw in ex parte communication. Ex parte communication does not mean you have posted a letter to your girlfriend or something.
Yes.
Ex parte communication means that one of the parties decide to open communication with a judge or magistrate or a decision maker in his case without the consent or notification to the other party.
Right.
That's ex parte communication. And in law, we hardly permit that.
Really?
Hardly. Because what it brings is conflict of interest.
Okay.
You know, unfair trial. Because once I know the judge and I'm able to speak to him, right? And the judge says, "I'll do something about it." When he comes to sit in court next time, what is he going to do?
That's true.
So that is ex parte communication is communicating to a party communicating to a judge, magistrate, or an officer, a decision maker, without the consent of the other. So,
If
for
there's
example,
the consent of that, it comes on notice.
notice, usually, as lawyers, when you are going to go to court with an application, you go by a motion supported by an affidavit. Why you are making such an application?
Okay.
Do you understand it
Right,
now?
I get it.
So, for example, if the Attorney General decides to write to the Supreme Court, hypothetically, that we have a case between myself and my son here, you are the judge, and then so please bring the date from 15 to 12, right? The legal etiquette and procedures requires me to give notice to NS that, look, the court will be sitting on the 12th instead of the 15th. In that case, it allows the NS and his lawyers to also prepare to come to court. So we avoid a situation where the case is caught, but because NS lawyers do not know that the case has been abridged, time has been abridged, he will not appear in court. And in law, we avoid surprises. So now, have you understood the two concepts?
I do, very.
Pre-bargaining,
Yes.
and also ex parte communication.
Absolutely.
Now, in plea bargaining, the accused himself alone cannot do this. If he is represented, even if he's not represented, the judge will require an independent witness to be there as he makes such pleas.
Is it a matter of law, a
It
matter
is-
of ethics,
It's a matter of law.
not ethics?
No, but in our situation,
Okay.
legal ethics constitute our law.
Oh, okay.
Yes, legal
Lawyers.
ethics under the Legal Professions Act.
Okay.
That's where we have Legal Professions Act and etiquette.
I see.
And many lawyers have been debarred, disciplined for violating the ethical conditions.
Okay.
Okay,
So it's grave.
very
It's
grave.
as grave as breaking a criminal.
It's a very grave offense because
committing a criminal
in
offense.
criminal law, the power of the state is marshaled against an individual, a single person who has a right to his liberties. But because he has done something against the state wants to punish him. So the whole, that's why he was saying the state, the republic.
Yes.
The republic versus Sampi Yale. It means that the whole country is against me. And in doing so, the law recognizes the overwhelming might of the state.
Right.
So certain procedures are required before an accused person, how he is arrested, how he is arraigned before court, how evidence is taken from him. So if, for example, you go to police station, they are taking your statement. The police must bring an independent witness to make sure that whatever you say, and the language of the statement must be understood by you.
Right.
So in law, everything is like mathematics, to quote the Chief Justice, her learned leadership. Law is by mathematical formulas.
Right.
Now, one of the preconditions of pre-bargaining is that first, the Attorney General can speak to an accused person Yesterday, I heard somebody saying that he cannot speak. No. Attorney General can speak to an accused person.
But under what circumstance?
But that's the question. When he's going to talk to an accused person who is represented, necessarily his lawyer must be there.
But I don't have a lawyer.
When you don't have a lawyer, the court must arrange, because it is a criminal case.
Yes.
The court must arrange either an independent witness
Yes.
or make sure that there's somebody who bears witness to what you are saying. Because you can change your plea. Are you following me now? So once there is this situation of plea bargain, the Attorney General must seek the consent first, the consent of the accused person's lawyer.
That he wants to meet I want to meet your client.
Good. And after the consent, the time, venue, and the meeting should be made known to the client's lawyer. And the law requires that he must be there. The client's lawyer must be there as you speak to the client.
So if the client himself, like in the case of Richard Adadi, who says, I want to see you, and the Attorney General says, I'll arrange for us to meet up through your cousin. Why didn't Adadi ask his lawyer to do that? And I'm saying, is it normal practice?
I was telling you that...
Sorry, Richard Jakpa, sorry.
I was telling you...
Richard Jakpa, sorry about that.
I was telling you
Just
that...
introduced me.
Yeah, sorry about that.
I
Yeah.
am telling you that I came not to talk about the case.
Oh, yes, okay, that's fine.
I came
That's
to
fine.
talk about
the legal principles.
legal
Yeah,
principles
to educate
that
the
are-
public. Right.
For the purpose of education.
I get it.
Now,
So let me rephrase my
If-
question. Can a client Suomoto decide to engage a prosecution or a prosecutor by asking for a meeting or by requesting for a meeting, that's the word I should be using, without notifying their lawyer about this request? Is that also standard practice?
if the Attorney General
Yes.
or a lawyer
Yes.
of the other party
Yes.
want to approach me, or I want to approach that one, the lawyer must be knowledgeable to say that, no, you can't see me without your lawyer.
Oh, I see. I see. I get it.
my point?
I get it. That
You
prosecutor
can't,
must
you can't
say
see me without your lawyer.
Okay.
Because in law, once I have a case with you, and I would normally write through my lawyer or I write myself. But once I write my lawyer, you, the defendant, would also have to indicate to the court that you have appointed a lawyer whose name must be listed in the case docket.
Yes.
That Moro is being represented by so and so.
Honest, yes.
Thereafter, all services of any procedure or process must be true to the lawyer
Okay.
or to both of you. And it's for good reason that we do things like this. And if you avoid it, things like what is happening
Will not even come up.
would be happening. Now, before the court are facts that has to be proven by law and not by emotions. Okay? What I find troublesome with our country now is the politics of everything. The politics of everything. And why has it come to this? I am beginning to believe that the institutions of state must guide themselves so that they are not influenced by politics in the discharge of their duties, especially with justice delivery. My son here was saying that, oh, the NDC brought the matter to public opinion, a public court.
Court of opinion.
Court of public opinion. And therefore, the Attorney General is also an MPP member. Once you get to that mode, we have destroyed the justice system.
But that's a fact.
No, that's not a fact.
Godfrey Dame is an MPP.
No,
Okay.
no. He may have been an MPP chairman.
Okay.
That's not important.
Yes.
Once he's appointed as Attorney General of the Republic of Ghana, he ceases to belong to any individual or groups.
Yeah, but that's on paper.
No. But we have had attorney generals in this country before who behaved as attorney generals. Don't give him the leeway that because on paper he's this and that. He has no responsibility to be political. Because if it's going to be political, then it's going to be Edmund is what? NPP. NS is MPP. Yes, Sam is NDC. So you would always deal with me.
Yes.
So whatever NS do, you don't see it.
That's true. Okay, that's the danger that kind of
and that is what we are seeing. You see, the oath that he swore, he was to do justice to all manner of people without fear of favor. All manner of people. That is the basis of our legal system. A judge, when he swears not to be biased to anybody. You know why Ghanaian lawyers wear the wig? You know why judges wear those cassock and those things? Because when they are sitting there in the cassock, you hardly recognize them.
Well, that's true.
You see, the impartiality of the justice system, especially when it comes to criminal cases, should be above board. And that is why when you are alleged, you must prove. And that is why when you are put before court as an accused person, virtually you have nothing to do. It is the duty of the prosecutions to prove my guilt beyond all reasonable doubt.
That's in criminal cases?
In criminal cases. It is not that the preponderance of evidence or the other.
That's for civil.
Civil. In this criminal case, it is the duty of the prosecution to prove my case beyond all reasonable doubt. The duty of the accused person is just to simply invoke certain loopholes in the prosecution's cases. And a slight or substantial attack on the evidence by the prosecutions may inure to the advantage of the accused person. If the prosecutions fail to prove the case not beyond doubt, beyond all reasonable doubt. And one of the concepts of criminal law is this. Between the two of you, they will ask, Moro, would any other journalist, reasonable journalist, have done what you did? That's why you bring the jury system.
Yeah.
Okay? Now let me address this question of how an attorney general converts an accused person into a witness. You understand?
Yes.
During the investigations, they would have known the principal actors.
Right.
And would have known somebody who was an accomplice or abettor. So it is easier to go to the accomplice or the abettor to say, look, you are part of this. If you can help us, cooperate with us, to be able to find the cause, who caused this matter, then we would do this, and that for you. All right? The purpose is not to coerce. And sometimes, as we see, they say police people have beaten somebody, that's coercion. But you reasonably bring him to accept that, look, I am prepared to be a hostile witness to the accused person.
Right.
So that's what we call the hostile witness. And that is allowed. But that is not to say that change your pleadings. You are forced to say this. Are you following me?
Yeah.
So that is how we convert an accomplice into a hostile witness.
Okay.
Do you want me to talk about this one, or I should end?
Which one is that?
The case before the court.
Yeah, the case. Well, that'll be great. I mean, in summary, what do you make of it? Are all of the things that Richard Jakpa and co are raising, are they material to the case in court?
We politicians, we should be very careful. Otherwise, one day, the population will rise against us.
Where's this coming from?
Before the High Court Accra, is Samuel Ofosu Ampafo being prosecuted for an alleged tape.
Yes.
No, so.
Yes, it was a leak tape.
Leak tape. Here we are with the Attorney General also in a leaked tape. But Moro, all the letters, all the press conferences, all these things that we are doing, we are addressing wrong facts. Okay? The tape in issue is a telephone conversation that happened between the accused person and the Attorney General on the day when the accused person was going to court. That tape is different from the allegation that they had met in the house
There have been
of
several meetings.
several meetings.
Yes, amongst
but
the
the
three of
tape
them.
in issue is that different. So I don't know where this obfuscation is coming from.
Right.
Now, if somebody is aiming at the Supreme Court judge, that's another matter.
Yes, I get that.
That's another matter.
Right.
Why somebody in the office of the Attorney General would allude to a discussion that took place between the accused person, the Attorney General himself, and the Supreme Court judge. Because question is, if that becomes an issue, are we prepared to bring that Supreme Court judge as a witness?
That's a good question.
Are we prepared? So those of you in the Attorney General's office who are piloting this or parroting this, please stop.
About it.
It doesn't make your case any better. The tape in issue is the telephone conversation between Jakpa and the Attorney General on a certain date.
Yes.
Which date everybody has now come to know. But the fact that I have, I've been following this case and printing daily happenings in the court. Every day I get it and I print it. I have about 6 of them.
Oh, so you think you've taken particular interest in
I have taken particular interest because, you see, I'm a politician. I'm a lawyer. Just that when power changes, I will not allow certain things that are happening now to happen to members of the NPP. Take my word. Listen to me. I am taking particular interest so that when it happens in future, I will say, when we were in opposition and this happened, this is what we said. So, for example, if we were discussing the Ssnit acquisition by Dame-Jakpa,
yes,
no MPP member should be proud to open his mouth and say, "Oh, he's an astute hotelier, businessman." Yeah. What about Ibrahim Mahama? The Ezon Cube thing. So like I said, we politicians should not make the citizens of Ghana tired of us. Because in countries where they have been tired of politicians, things have happened.
The people rise up.
See, if you read this document I have, Moro, I can send you. The whole issue in court must not be about anything but the terms of the contract.
True.
A lie?
Yeah.
Nothing more than the terms of the contract.
Yeah.
But of course, the whole issue was started by the president himself, unfortunately. On the 28th of January 2019, I think he was taking delivery of these ambulances.
One ambulance per constituency.
And let me read what he said.
Right.
In December 2015, 200 ambulances were supposedly purchased by the Mahama government, out of which only 30 arrived in the country. As though this was not enough, the 30 ambulances that were delivered were declared not fit for purpose. This was what the president said. Yeah. And if you continue, you see other things that prompted this prosecution. Have you followed me?
Yes, I do. I follow you.
Soon after that, this prosecution started. Look at the ambulances behind you. Are they not Mercedes-Benz ambulances?
Of course they are.
The original ambulances that were supposed to be imported by Mills was supposed to be Sprinter ambulances.
Yeah.
But at the time we got clear with this import, Sprinters have been seized. The manufacturers were no longer producing it. So these ambulances, were they the ones that Mills imported or what? Let us take it that these were importation by His Excellency Nana Akufo-Addo.
Okay.
You will see that the ambulances stayed at the forecourt of the State House for a long time. Why? Because the engineers from the company were installing the medical equipment. And the laws of insurance, when you are shipping these vehicles, the technical equipment, you don't install them for the purposes of breakages and destruction.
It's only when they arrive.
So what you do is that you ship the ambulances in a vehicle form, empty.
Empty.
There are things like beds you can install.
Yeah.
But the technical equipment, you ship them separately. And that is why these ambulances, when they came, they spent about 3 months at the forecourt of the State House. And you could see the engineers of the company installing them with the staff of the Ghana Ambulance Authority, whatever it is. Are you following me? So, if you go to inspect a vehicle that has arrived and just declare that they will not fit for purpose, you are not doing this country any good. And as I speak to you, the allegation is that the medical equipment that were to be installed in the Mahama ambulances are still at the port. And the ambulances, if they were not the one that were one district, one factory, and then it means that those ambulances have been parked somewhere. Are you following me? Which means that for 8 years, because of our political fight, the people of this country have been denied the use of those ambulances.
I'll take a short break. I'm told I've been denied, so please pause there. I'll take a short break. This is just about a minute, and then I can come back to you. So this is Inside Pages. We're getting some very interesting education from Ambassador Sampiale. You can always expect these kinds of submissions from him. He's a statesman, so he likes to rise above the hardcore politics sometimes. We'll take a short break. We'll be right back. All right, welcome back. This is Inside Pages on Metro Television. So Ambassador Piale is on the floor giving a submission. We have about 7 minutes more to go, so I'm sure that you'll wrap it all. You would summarize everything for us. I enjoyed the legal education that you gave us, so that it will help us understand when you summarize the matter in issue. Please go ahead, sir.
You see, the NDC may be wrong or right, depending on who's judging the matter.
Okay.
But in local language, you said once bitten, twice shy. I was in my TV in my room when my classmate Martin Pegu said that he challenged this Attorney General about the inclusion of ACP Agbojo.
Yes.
And he said, we added ACP Agbojo so that we can make the case weighty.
Okay.
So the Attorney General can do this? Right. Is it the same principle why he's joining Jakpa and
Atuforsen?
At one point of the judgment, the judge said, what is this case about? The judge herself questioned.
Yeah.
It started with non-authorization of the procurement.
Yes.
Then said, Tekpe is alleged to have gone to court to say that I authorized it. One of the stance of the Attorney General is that the ambulance that were imported were not fit for purpose because Alex Egwefia had said so. if you do the review and put Alessandro's statement in context, he said, in the state as I saw it, without the installation of those technical equipment, it will not be fit for purpose.
Right.
Then we politicians drag it into, they are not even, they are for trotros or whatever. But every ambulance that is shipped worldwide,
it's shipped empty. And then when it comes,
you so we can see the picture behind you.
Yeah.
In my conclusion, the Attorney General is such an important person in the country. All his importance aside, he is the Minister of Justice that should seek justice for all. Ernest, don't go anywhere and say that Attorney General is a member of the MPP.
So it was in response to
he may have been,
question that
he may have been the MPP chairman. You know, our justice system, in the words of the former Chief Justice, is becoming too predictable. In the words of the former Attorney General. And I, sitting by my TV every day as I watch Mr. Albert Kandapa, who said, if all your judgment is for us, the people, you remember that episode?
I remember.
I have been to bar conferences where the AG took on John Mahama, 2 bar conferences, took on John Mahama as though he was earnest, speaking on a political platform. So in one of the conferences, some members of the bar had to walk out when he was speaking. Is it the kind of Attorney General we are looking for? You know, if you are Attorney General and you pick a telephone to call somebody, emotional intelligence should let you understand that you may be recorded.
I get it.
No, so. And true to his fear, he was recorded. And that is the subject matter of the tape. The tape is the one in court now.
Yeah.
Not the Supreme Court judge and all those, which I don't want to refer to.
No, I get it. It's the phone conversation.
It's a phone conversation. I have just read what you sent me. And with all due respect, the affidavit, the pleadings, are not the language that should come from an Attorney General.
Right.
Because in criminal prosecution, every word you say, every sentence you make is contestable. You must prove with the evidence. It is not the NDC that asks you to call Jakpa. So if you cook your food and you put it on my table and you say, Sam, over to you, won't I eat?
I guess this is where.
In wrapping up.
Yeah, because we just have a minute.
The ambassador mentioned.
I like where you landed.
You see, where he was talking about the accused person receiving a call.
Yes.
If I get a call that you have to meet me here or do this or do that, the first person I will also call would have been my lawyer.
Okay.
So we will not put on, and please, just 2 minutes or 1 minute.
Yes.
He mentioned something right now I want to react to. You see, the president made the president's speech in respect of the ambulances was made in January 2019.
Right.
That's what I said.
These ambulances arrived, the supposed not fit for purpose ambulances arrived in Ghana somewhere in 2015 or early 2016. That's what I said. So what I'm saying is that you look at the time. It's taken close to 2 years or more. And we are still saying we couldn't install the equipment that were supposed to be in these ambulances. So as for me, I have tried. I will land quickly on this. I have tried to avoid the actual details and discuss this matter in the context that the thing is in court. Let it remain in court. All the facts have been presented. But if you take it and make it a political conversation, I will be sitting here with the ambassador discussing it.
Let me say something.
Right. But if we remained in court and dealt with it in court.
What we are losing sight of, Chief, I beg you. These ambulances, it was a loan.
It was a loan, yes.
The Commander Sugar Factory was a loan.
They're rotting away.
Saglame was a loan.
No, that's not what we are discussing now.
No, what he's saying is that as we're having all this conversation, remember that we're wasting away state
the
property.
money. Saglame was a loan. We took $200 million US from a Swiss bank with interest.
Well, I guess I guess you've made your point.
And we didn't finish. And we left.
Your point is that in all of this, we're wasting the taxpayers' money.
That the monies that we are throwing away or we have put in projects that we never landed are now being paid for. And the NDC will come back and come and tell the MPP that you did this and you are not able to pay your debt.
Thank you very much for watching Inside Pages. Thank you very much for watching Inside Pages. Ambassador, I beg you, we ran out of time. But listen, what he said is something that we all as Ghanaians must ponder over.
That we use the state, take money, we use state resources, take money, and we never.
All right. Thank you very much for watching Inside Pages. Have a wonderful weekend. Thank you very much, Professor Osai Kwapo and Justice Abdullahi. Have a wonderful weekend. Bye-bye.